The following discussion and materials are to be used for informational and training purposes only. They are not intended to supplant the requirements of the Assessor's Reference Library, the Colorado Constitution and statutes, and relevant court case law. You should consult and rely upon appropriate legal authority. Welcome to the Colorado Division of Property Taxation's video library. We hope you gain useful information and enjoy our presentation of this course.
Welcome everybody. I truly hope you get a lot out of this class. This first part, as I said, is dealing with legalities. It's not terribly flashy or a sexy part of appraisal, but it's obviously stuff that you do need to know. I mean, it's kind of one of those things where you need the check boxes, all those things that you need to do or have to make sure that you are competent and you are given credibility when you're dealing for a case at an appeal hearing. Whether that's at the protest level, whether that's the county board level, VAA and up. Okay, these are all things that are really necessary and things that you need to be aware of just to ensure that not only are you doing your job correctly, but that there's no undue problems with your appeal and your credibility as you go through that process. So we're going to start on page 1, and there is a quote from a court case that was published by the Colorado Court of Appeals in 2009, the top on page 1. And that quote is, based on the comprehensive legislative structure regulating them, real estate appraisers practice a profession involving knowledge or skill, and their conduct should be judged according to the tenets of their field. They did lay down a marker that says we understand that this profession needs knowledge and skill, and because of that, that is the basis for which you will be judged on your work. So the next line down on your page, so we start with ad valorem appraisal and USPAP, or the Uniform Standards of Professional Appraisal Practice. And USPAP is the main tenet of our appraisal profession. For those of you who've taken the class, most of you or a lot of you in here have taken that class from me. When you've taken that class, you understand that USPAP applies to all appraisers, whether it's an ad valorem or not. And all of you are required, once you are licensed, to follow the requirements and tenets of USPAP. That doesn't mean just in the appraisal work that you do, that also means in the reports that you present. And we've talked about record keeping for your reports and all the different rules that go in USPAP. All of those things are required of you. Now, we do have some jurisdictional exceptions that we'll talk about for Colorado. So, USPAP was created to promote and maintain a high level of public trust. We talked about that as being the main tenet. So the idea there is that the work that you do will make sure or ensure that you can maintain a high level of public trust. That also means that you should be given the benefit of the doubt that most taxpayers in the work that you do will trust you. Now, in the assessor's office, how many of you feel, for those of you who've been through protest, and most of you have, how many of you feel that when your taxpayers come in to appeal their value, do you think that they trust you? What do you think their main motivation for coming in and protesting is? What's that?
Reduce their taxes.
Yeah, that's exactly right. It doesn't matter if the value's good. They just know they have the ability to possibly save some money. And all it takes is a little bit of time. You should give everybody the benefit of the doubt. You should give them the benefit of the doubt and listen to what they're saying and find out what their particular issue is, because there is a statistical chance that they are overvalued, just based on statistics. So I would suggest to you not to take the protest process as any sort of adversarial point or issue, but to embrace it and say, okay, if there's something I can do to help somebody and fix this, that's what I want to do. And if you do that, the PR side of your job is going to be significantly helped as well, because you are helping taxpayers, and again, in coffee shops and everything else, they will hear about that, and that will help your job in the future greatly. So the other thing that USPAP does for you is when you are USPAP compliant and your report is USPAP compliant, then it definitely demonstrates your professional credibility. And there's nothing greater than you can have, particularly at any sort of appellate hearing that has an outside decision maker or judge, than to have that professional credibility. At the protest level, it's you, maybe your boss. You hear the appeal, you take down the information, you have an opinion on whether the property should be adjusted or not. Or sometimes you don't know, or in some cases, the supervisors are the ones who ultimately make that final decision. Well, if that's the case, that's fine. But again, ultimately, you want to make sure that you maintain that credibility, especially when you're going to district court or to the Board of Assessment Appeals. The other reason why you should follow USPAP, I mean, not only for those of you who are licensed and you have to maintain your credibility and your license and be in compliance, is that it is required by Colorado law. So from all sides, USPAP is a basic tenet. Now, it's not the only tenet in our field, and we do have exceptions to USPAP, and that's where we get into our jurisdictional exception rule. And our jurisdictional exception rule essentially says that if any state law or regulation precludes compliance with a portion of USPAP, then you need to comply with the law. What's the most common jurisdictional exception that we all deal with on a regular basis in the assessor's office?
Market value, sales comparison.
Right, so yeah, so all of those three things together. So on residential properties, when you're coming to market value, you are limited to the sales comparison approach. USPAP says that you have to look at all three approaches or whatever approaches are the most reasonable. And the biggest example there is apartments. So apartments in Colorado, why do people buy apartments?
Make money.
To make money. They want rents, right? So in theory, when you have a property that generates income, what is typically the best approach?
Income approach.
Correct. So that's typically the case. But because they're classified residential, we are limited to considering only the sales comparison approach when valuing those properties. So in that case, that is a significant jurisdictional exception. So the one nice thing about USPAP is that they did institute this jurisdictional exception rule where they said, appraisers, you must follow these in order to be in compliance, but we also understand that the 50 states have 50 different constitutions and might have their own rules in their jurisdictions. So those jurisdictions are going to override the requirements that we have in USPAP, and that's where we get to our jurisdictional exception rule. All right, so the main tenets that we need to be concerned with in our field. So it all starts with the Constitution. The Constitution is the basis for all things done in Colorado law here in our state. So we're going to start here. And then we have our Colorado revised statutes and court case law. And when we talk about case law, we're essentially referring to cases that are published. When a case is published through either the Colorado Court of Appeals or the Colorado Supreme Court, that court case and the language in that case essentially becomes law. So whenever anything like that changes, the division has to follow not only changes that happened at the legislature when bills are run and may change how we do something, then also when court cases are published, we have to take a look at that and see if that changes any of the work that you all have to do. Is there a new way that we have to do something? So we track all of that legislation and we track every published court case every week when they get published through the Colorado, I think it's Pacific 3rd now. Whenever something gets published, we have to read those and take a look at those cases to make sure that doesn't change anything that you all necessarily have to do. Then, so after the Constitution and case law, we then have USPAP. USPAP would fit usually right in there because the division, other than any jurisdictional exceptions, is not going to override USPAP. Then you have the Assessor's Reference Library. Those are the ARLs that we publish, And there is a court case out there that mandates that you all, as assessors and appraisers in ad valorem, must follow the rules that are in the assessor's reference library. And all of those rules are approved by the Statutory Advisory Committee and the State Board of Equalization. Beyond that, any changes that we make to the assessor's reference library goes to essentially the staff appraisers for the governor, which is called LLS, or Legislative Legal Services, and they review any changes that we make. After everything is done, they review to make sure that any changes that we make are in conformance with the law and that we are not going above and beyond the law or above the abilities of the property tax administrator. So there are numerous levels of review for all of this information just to ensure that everything we're doing is legal, which is why you can always cite the assessor's reference library in your cases and the things that you must do as a part of your job. From there, we have the Board of Real Estate Appraisers through the Department of Regulatory Agencies. They have their own rules. We're going to talk about some important ones from there. The BAA, in order to go to the BAA and the things they require, we're going to talk about some BAA rules this morning. We're then going to talk about some professional conventions, and this is just in being an appraiser, some things that you should be aware of in dealing with that, and a lot of those professional conventions fall under our USPAP category. So the first tenet we're going to start off with is the Constitution. This is on the middle of page 1, and I'm going to hit some of the highlights. I would suggest at some point, because this material isn't too thick, at some point I would just read through this whole class document just to get a good idea of some of the things. I'm going to hit all of the points that are salient and the most important things that I want you to remember. So not only do you get them visually from the material, but also so that you hear them from me. But I'm not going to touch on every single thing that's in your material. In the Constitution, we value our values are based on the principle of ad valorem, or according to value. Everybody have that on their state exam for your first level license. What does ad valorem mean, right? According to value. So typically when we say ad valorem, that's in relation to property tax appraisal, is usually where we hear that. In the Constitution, it says you must have just and equalized values. Those are the values that you must come up with for property tax purposes, and that you shall determine the actual value of the property. So, as Kyle said earlier, it does talk about market value when we talked about the sales comparison approach. The statute in the Constitution actually says actual value. Now, the nice thing about that is we do have a court case, and the name escapes me at the moment, but there is a court case out there that was published that does say that market value and actual value are synonymous for property tax purposes, which is why we just refer to market value all the time. It also says that we have to have appropriate consideration of the cost, market, and income approaches to value. And then obviously we have exceptions to those three. Otherwise, you are required to consider all three of those. And the two examples that we give here, residential and also agricultural. Agricultural is a jurisdictional exception is because you do not consider all three approaches. For ag properties in Colorado, there you base that value on the potential net income to the landlord, and it's capitalized at a rate prescribed by law. So it's a very specific procedure that you're required to do to establish agricultural values. So out of the Constitution, we have the Taxpayers' Bill of Rights. And this is Article 10, and in TABOR, or the Taxpayers' Bill of Rights, it has some requirements for you. So you have to send NOVs annually for all of your property owners, and they are allowed to be appealed annually. So that's where we have our month of May, where we have our protest period, where everyone's allowed to come in and appeal if they think that their value or classification is unjust. It also says that there is no presumption in favor of a pending valuation, meaning that they're not going to assume that your value is correct, although it is incumbent upon the taxpayer to show that your value is incorrect, show that their value is incorrect when it goes to a higher level of appeal. Now, here's the interesting thing. A lot of people, and this happened for years and years, a lot of people came in, and I've heard this when I was in Arapahoe County a million years ago, and I've heard it past few years at BAA. People come in and say, well, they're not giving me what they think the value of the property should be. They're just complaining that the assessor did it wrong. They're allowed to do that. So there's no presumption in favor that they have to give you a value. Normally, the Board of Assessment Appeals will ask a taxpayer what they think the value of the property is, but they don't have to give a number. All they have to say is, my value is incorrect because the assessor's office didn't do this. So it also says that government sales can be a valid indication of market value. So if you have sales to or from a governmental entity, that doesn't mean that you can disqualify those sales right out of the gate. Okay, a lot of times when governments acquire or sell property, they have appraisals. CDOT, for example, has an army of certified generals that they use in their office to figure out what the values of these properties are so that they can use eminent domain to capture land area to build and expand highways and roads, for example. So, government sales can be a valid indication of market value. Your value must be stated on your notice of value. And then once again, Tabor was actually the place where we were limited to the market approach for residential properties only. Those were the main things we're talking about or you need to be aware of out of the Constitution as we get started. From there, we're going to talk about statutes and case law. I think most of you know our title as a part of the Colorado Revised Statutes. Do you guys all have a copy of the statutes books in your office? They look like this. There's usually a whole string of them, and they come out annually because whenever laws change, they have to put out a new version. So we get new versions of these books every single year with the laws updated and published in them. Title 39 is the property tax title. So Title 39 is where a lot of our stuff comes from, and I'm not going to rehash all of that stuff here because most of you are familiar with Title 39. If you're not, all you have to do is take a stroll through the Assessor's Reference Library and see how many citations are out of Title 39 for all the rules that we have. We're going to talk about a different title, though, in accordance with this class we'll talk about in a minute. So, Title 39 affirms the Constitution and the requirements in the Constitution, particularly with dealing with the three approaches to value, except for our jurisdictional exceptions. It also then establishes our appraisal date and also our level of value. So those two terms are synonymous. So in legalese, the level of value is that point at which you set that value. Okay, so it's that level of value. We have coined the term appraisal date because that's what is in USPAP, and truly that is how we think in terms of appraisal language. So whenever you see or hear the term level of value, they're simply talking about the appraisal date. And the appraisal date is
June 30th.
June 30th of every even year. Good. So your appraisal date is June 30th of every even year. Your assessment date is January 1 of
2017
every year. Okay? So your appraisal date's June 30th of every even year, but your assessment date is January 1 of every year. How many of you have had, let's say, difficulties in explaining that concept to taxpayers? It's crazy, right? It's one of those really weird things where you're like, yeah, so your value is actually based on June 30th, and usually that's a problem only when the value has changed dramatically from the prior June 30th, which is why in a reasonable or increasing market, a lot of taxpayers don't come in and appeal in a rising market. Why?
Usually it's going up.
Right. By the time they get their NOV, Their value's way lower than what they could sell it for. And most taxpayers usually think that way. In an increasing market, they think, oh, well, the assessor's office value is always lower than what I could sell it for, so there's no way that I can protest or get anywhere. When the market is on the decline, that becomes a problem. Because all of a sudden they get a notice for a value and they're like, I can't sell my house for this. And then you have to say, well, you're right, but this value we established is almost a year ago. Well, why is that? Well, June 30th, and then there's this January 1st assessment thing, and then we don't send the NOV, the notification, actually till 4 months later. So we're talking about 10 months previously, based on what your property looked like on January 1, this was the value as of June 30th of last year. It's really crazy. So I hope that through this process, and if you haven't already, you will find a way to effectively communicate that idea to taxpayers, because that's crucial. Crucial for them to be able to understand that. And if they don't believe you, you may have to go to Title 39 and show them. And just say, here's the June 30th date, here's the assessment date, so we have to look at what your property looked like here, but all of our values stop on June 30th. And there's a couple of court cases I'm sure that Laura will talk about this afternoon, which also help to establish the fact that you are not allowed to look at any information beyond that June 30th appraisal date. So, then again, of course, we talked about through case law, the Assessor's Reference Library is binding on all of you. And that court case citation is actually there on page 2. It's Huddleston versus Grand County. There we have from Title 39. The title we're going to focus on next is actually Title 12. And that's the title that I have here as my prop and demonstration purposes. So Title 12 is actually for professions and occupations. And so part of that, in their defining in professions and occupations, there's some interesting rules that you all need to be aware of when we're talking about our property tax appraisal. So at the bottom of page 2, you can see there that they have definitions for appraisal, appraisal report, etc., and then there's a client. We're going to start with consulting services. And here's why this is important. So under consulting services, it includes advocacy in regards to property tax assessments and appeals. So you can be licensed in Colorado and you are allowed to advocate in regards to property tax assessments. That is a jurisdictional exception. Why? What's that? Partially. It includes bias, but what's an important tenet of USPAP as being an appraiser? Independent, impartial, and objective, which means you can have you cannot have any advocacy. As an appraiser, you are independent, impartial, and objective, which means you cannot advocate for, other than defending your value, you can't advocate for anybody. You are independent, impartial, objective. You are looking for what the market says this property is worth. So you're not advocating for anybody. Well, in Colorado, under the definition of consulting services, it includes advocacy for property tax assessments and appeals. Now, if an appraiser provides work other than a consulting service as a disinterested third party, this work is deemed as an independent appraisal. And the independent appraisal is there under paren 10 on your page. And it says the independent appraisal means an engagement for which an appraiser is employed or retained to act as a disinterested third party in rendering an unbiased analysis, opinion, or conclusion relating to the nature, quality, value, or utility of specified interests in or aspects of identified real estate. When you are doing an independent appraisal, it requires no advocacy. However, a consulting service can be included with advocacy for property tax assessments and appeals. So on page 3, one of the things I do want to show you. So first we have a definition of an appraiser. One who provides an estimate pertaining to real estate and who possesses the qualifications, ability, and experience to execute or direct the appraisal of real property. And so it starts there, but I do want to bring up that the definition of an appraiser does not include personal property. Now, you may have the title. I saw there was a few of you in here who do personal property. You may have the title of personal property appraiser, but since it is a real estate appraisal license, then when you do just personal property, according to the law, the term appraiser doesn't apply to you. Now, I don't want you to take that to heart and be disinterested or have a problem with that. That's not my intention here. Just according to law, when talking about appraisal, it sticks to real estate because of the licensing function of that office. All right, so this is all, again, under Title 12. Sometimes you are not subject to disciplinary actions based on the work you do for the office. So, might not necessarily mean all the time, and I'll clarify that when we get there, but you kind of have a buffer from some of the work that you would do for the assessor's office from suffering any disciplinary actions from the board. And as I said, we'll talk about that on page 4. Okay, so 1261-706 in the Colorado Revised Statutes actually name the 4 levels of licensure. They are certified general, certified res, licensed ad valorem, and then just the license level. Now, I know, and this is the way they are in the statute. So remember that most of you, we provide the education to get you here for the licensed ad valorem level. If you want, when we say a higher level license, it's just a different category. There are additional education requirements for the other levels. So, show of hands, who's got a certified general? Who's got a certified res? Who's got a license? And who's licensed ad valorem? Okay. Do you all, for those of you who have licensed ad valorem, any of you have the ambition to get a higher level license? Okay, Josh, Jake. Okay. So, at least at present, we don't teach the education required for these higher level licenses. They are not required by law. So it would require you taking education outside of the division classes. And then also, you can use experience from the assessor's office to get that higher level license. Under this same heading, under 706, a county assessor or employee of the assessor's office who is a licensed ad valorem appraiser may not perform appraisals outside of their official duty in the assessor's office. And then if you flip the page to page 4, about halfway down the page under paren 4A, any of these licenses entitles an appraiser employee of a county assessor to perform all real estate appraisers required to fulfill that person's official duties. So we move from 1261-706 to 1261-713, and we're on page 5. So some prohibitions against things that you cannot do as an appraiser here in Colorado through the law. First of all, you cannot have been convicted of a felony. You cannot have accepted anything, whether it be fees or anything else consideration that would influence your decisions. You cannot provide false advertising for your job or who you are. You cannot commit fraud. You cannot violate USPAP, and you cannot be incompetent. So those are those rules. If you go down page 5 and to the top of page 6, you'll see a couple of others in there. I hit the highlights, but I just wanted you to know that there are some of these prohibitions that are based in law that are directly in Title 12. Okay, so under 719, there are some special things for us, for county assessors. You shall not present yourself as licensed or certified if you're not. So that speaks once again directly to the ethics rule from USPAP. You must not mislead. You are required to get licensed within 2 years of being hired as an appraiser. Now, you can be hired as, I think like in Arapahoe County, Nick, they hire initial people coming in as what they call data collectors. So they're not officially appraisers. So you don't have to be licensed within 2 years because you are not technically an appraiser yet. But if you're an appraiser, the statute says that you should be licensed within 2 years. So I know a lot of you, when you get hired on in your assessor, when they talk about that 2-year rule, have some of you heard that you have to have your license within 2 years? Okay, great. Yeah, it's directly set in law that you have to do that. And that requirement does not apply to the assessor. There was a court case out of Adams County a long time ago. The assessor's name was Pat Reel, who actually went all the way, was it the Supreme Court? Went to the Supreme Court and basically said that I was elected by a vote of the people for this position, and you cannot place any other impositions on me other than that for an elected office. Went all the way to the Supreme Court, and the Supreme Court agreed. So when you are hired as an appraiser, you must be licensed within 2 years. Your assessor technically doesn't have to be licensed at all. Their only requirement is to get elected by a vote of the people, and it kind of ends there. Now, they have other responsibilities under the law, etc., but being licensed is not one of them. Our next section at the bottom there, we're going to talk about the Borea rules. So we talked about the Constitution, we talked about the Colorado Revised Statutes and case law, and as we said, we're going to get into more case law later with Laura. We're going to now, after we get out of the Colorado Revised Statutes, we're going to discuss the rules that were adopted by Borea. So the Board of Real Estate Appraisers is under the Division of Regulatory Agencies. It is a sister state agency to us, but we are completely separate. So the board is the governmental agency that enforces all of the rules for appraisal licensing. They are the ones that you have to send your credentials and your logs to in order for them to approve so that you are eligible to get your license, and they're the ones that you apply for the license. So they manage all of that. They are under the Division of Real Estate, under the Division of Regulatory Agencies, and they produce a document called the Real Estate Manual every year. And all of their rules are in the Real Estate Manual. And there are some that apply to you all, so we're going to go through a few of those as we see up here on the board as well. So the first one we're going to talk about is Board Rule 1.10, and that's where it talks about USPAP being adopted by the board for all appraisers in Colorado. Now, this isn't specifically for ad valorem, this is all appraisers in Colorado. And then Board Rule 1.11 is where they adopt that all of the rules from Borea apply to all Colorado appraisers. So the board adopted USPAP, and then they had to adopt a rule that said that all of our rules now apply to all of you. Moving to page 7, that you can only have a contingency fee when an appraiser is acting as an advocate for their client. And remember, we go back to that advocacy that we talked about in the law that says if you are providing a consulting service, that you can be an advocate for property tax assessment and appeal purposes. And then finally, or on this slide on Rule 1.29, it talks about the appraisal process and that all appraisers must be compliant with that appraisal process, being in compliance with USPAP. Rule 7.19 states that every licensed appraiser has to complete a 7-hour USPAP update every 2 years. So conformance with their continuing education. This was just recently changed because as of a few years ago, when you renewed your license, it was renewed for 3 years. And they just recently changed that since USPAP does update every 2 years. The board had decided to go with that same time frame. So They are requiring that you do take one course every 2 years, and that's now in conformance with new USPAP versions, as well as the licensing requirements where you have to update once every 2 years. Then 11.1, it says that USPAP was adopted and incorporated by reference in Board Rule 1.10. This is the one where they just update it for each version. So you can see there under 11.1, it says that the 16-17 edition of USPAP, incorporating amendments made through February of 2015, will remain in effect through December 31st of 2017. Beginning January 1 of last year, the 18-19 edition will be in effect. So apparently they've made their rules date specific under this one, so every time a new USPAP edition comes out, they have to update this rule for those new editions as well. And then Board Rule 11.3, those are the requirements for when an appraiser performs an assignment based on a contingency fee under 11.3. And you can see there they have that A, B, and C down at the bottom. But these rules you can get from the the real estate manual published by the Division of Real Estate. All of these rules are in there that you can follow. So this is just kind of a quick and dirty on some of the rules that are required of you all. At the top of page 1.8, when you want to look at BAA rules, here is the citation. So it's long, but if you type this into your browser, that'll take you directly to the rules that are required by the BAA for presenting there. Shorter version may be just to go to a search engine, put in Board of Assessment Appeals Colorado. It'll take you to their website, but sometimes the website isn't the most intuitive to navigate. I know we're constantly trying to update our websites to make those easier. So if you want the direct rule site, there it is in your material and up here on the board. Our next section there is our professional conventions. So some of the things that we have to do attending this class: attending a CE class, attending a QE class for qualifying ed. Obviously, you're going to want additional qualifying education for higher levels of license if you want to go there. One of the things we talk about in scope of work and AO 24 is what do my peers do? We'll talk about that question here in a minute. And then through IAAO, how many of you have heard of IAAO before? Okay. It's the International Association of Assessing Officers, and they are a national assessment organization that a lot of the states of our union follow from assessment protocol and look to their education and their publications for information. We haven't been associated with them in Colorado for quite a few years, although that might be changing soon. There has been a push recently to bring the IAAO back to Colorado, and so there are some individuals in both the assessors group and at DPT who are looking at that for additional education opportunities. One of the things that they put out in one of their original appraisal and assessment books, a really good quote, is that assessors need skills in both mass appraisal and single property appraisal. And single property, you need to defend the values during an appeal and to appraise special properties that do not lend themselves to mass appraisal techniques. And when we talk about the different levels of appeal, that becomes really important because you're going to establish your mass appraisal values using your models, but the vast majority of the time you are going to defend those values or defend an independent value with single property appraisal techniques rather than just the model. The best case for you all, and dealing with this actually isn't in your material, this is just up here on the board. So your best case is that you are prepared and in conformance with USPAP when you're going to hearing. Ideally, when you have an appeal, you conclude it at the assessor level. If there's a problem and you figure it out, you fix it, just like we talked about earlier. Presumption is that you aren't always right. It's that there could be an issue that the model didn't work well. So They come in to protest and you just fix it. You get your data, you fix it, the problem goes away. However, if they do go on and they aren't satisfied with your decision, and we know that there will be some people that aren't always satisfied with your decision that'll go to CBOE and higher, you then have to decide whether you are going to defend your mass appraisal values using standards 5 and 6, or whether you want to do a single property appraisal, which is standards 1 and 2 under USPAP. So there's a statement about this where it says you're required to use standards 1 and 2 at the third level of appeal, which is a trial de novo. That's a little bit misleading, and I'll tell you why. You are not required by law to do a standard 2 report at BAA. So we remember standards 1 and 2. Standard 1 is single property appraisal development. Standard 2 is single property appraisal report. Standard 5 is mass appraisal development. Standard 6 is mass appraisal report. You can take a standard 6 report to the BAA. Here's the rub. Legally, you're allowed to do that. The vast majority of the members on the board are fee appraisers. At present, we do have a couple of board members who do have mass appraisal experience, but in order to do a standard 6 report, you have to explain your model specification, your model calibration, and all of the value changes that are inherent with that model. Most of the board members don't have any experience with that. So not only are you defending what you did, but you are having to teach them how it works. That generally isn't a great recipe for success because you don't have 4 days to teach them how to CAM a system. So that's why 99% of the time a standard 2 report is done. Here's the other thing. We talked about mass appraisal results do give you single property values. But they give you single property values for a large quantity of properties, correct? Did your model do so well that you wouldn't come up with a more specific value if you did a single property report on your subject? That's the question. If your model did it perfectly, and it might, in the case of a condo or a townhome, your model might be spot on and get it dead perfect. Otherwise, if you did a standard 1 appraisal and a standard 2 report, would the value be more specific to that property? Most of the times, probably. So there's only been one time where I know that an assessor attempted to take what is now a standard 6 report to the Board of Assessment Appeals, and the board recognized that they could not just eliminate it and throw it out, but they didn't give it a whole lot of weight for all of the aforementioned reasons. So just wanted you to be aware of that. If you're going to start doing higher level appeals, you'll want to get more proficient in writing standard 2 reports for those levels. So how well do you apply USPAP and mass appraisal? So for example, the division of your workflow, is it collaborative or is it individual? Okay, just some things to think about. Usually when you are doing a mass appraisal, collaborative is really helpful. I know in a lot of cases there are groups of people that will do a lot of the collecting of the data, and then there are analysts who will set values and move the model, but hopefully you get to be a part of both of those things if you're working on that, because that gives you really good experience. What time constraints do we have on getting our work done? So what sorts of reports do we publish? What is the impact of the record keeping rule from USPAP on you? Most of the time that's pretty simple, right? From a record keeping rule standpoint, what is your work file? It's your entire office. All of the things in your work file, all of your maps, all of your legal descriptions, all of your CAMA data, all of your sales, everything in there is part of your work file. So we know that we have to keep track of that. Thankfully, most of that is done on your CAMA system, but you might have some other paper things as well. Plat maps, for example, part of your work file, but they may not be in your CAMA system. So when we're talking about our work file, so you deal with USPAP impacts all the time, even in your daily work, even if you're not necessarily thinking about USPAP every day. So we have training in the office, production of inter-office templates, narrative formats, standardized documentation, summaries of oral reports. How many of you knew that when you testify at the BAA, when you're defending your appraisal, that you have to have a summary of that in your work file? Did you know that? Okay, just a couple of you. Requirements from USPAP are anytime you give oral testimony, you have to have a summary of that oral testimony in your work file, which means that for most of you, when your counties go to the BAA records all of those hearings. You should get a copy of it. You should get a copy of it, and you should keep it on file whenever you go, because you need summaries of that oral testimony in your work file. That would be an example of the summary of that testimony. So you should have a recording of all of those. Now, I talked to the former director of the BAA, and they've been recording these now, I think, for 6 or 7 years-ish. And at one point, they said they were going to start purging old files because they were going to run out of space eventually. What I did hear is that up to today, I think, they haven't purged any of those yet. So even if you have old files back there and you haven't gathered any of those, you can go back and get recordings of those hearings previously, because those are still stored. But eventually those are going to go away. Now, remember, still part of the record keeping rules, so you do need copies of the oral testimony. Do you remember what the time frame is on the record keeping rule? 5 plus 2, right? So minimum of 5 years, and then 2 years after any final disposition from a judicial hearing. So, especially if you have a Court of Appeals case, or if you have a Supreme Court case, if you have BAA testimony on record, you have to keep it 2 years after the final conclusion was made at that court level. You need to keep that on file as a part of your work file. We also think, a lot of times think that there's a perception that USPAP only applies to written reports. See the previous bullet point. That certainly is not the case. Anytime you give oral testimony or an oral report, you need that information as well. And we talked about there's a perception that USPAP is only relevant at the third level of appeal. Well, as we saw on the previous slide, it applies to you every day, whether you're working individually, whether you're collaborating, especially when you're talking about modeling and setting values in your models. All of that has to fall under Standard 5, our mass appraisal development. So part of 1261-706, we have this statement, then we get back to the material, and I'll finish up my section. Appraiser employees of county assessors who are employed shall not be subject to disciplinary actions by the board performing appraisals beyond their level of competency. That's where we went back to your competency buffer. But remember, it's not really a buffer, because it's only competency if you don't have the competency for that assignment. If you are expected to have that competency, you should make sure that all of your appraisals are compliant and there's no USPAP errors or problems. Otherwise, you could be subject to disciplinary action. All right, so we'd already answered this. Does not subject to disciplinary action exempt you from compliance? We already said no. Clearly, the ethics rule is one thing, and also the Colorado Revised Statutes require you to be in compliance with USPAP. We get back to USPAP now on the bottom of page 8, and we're going to review some USPAP information and some appeal information real quick. Any best case at any level complies with USPAP. We're good with that. Given appropriate consideration to the definition of the appraisal problem, and so this is step 1. in the appraisal process through USPAP, and hopefully you recognize these bullet points as being part of the definition of the problem from step 1 from your previous classes. So we need to make sure we comply with that. Who's our client? Good. County treasurer is our client. When you present at the third level, who is your client? It's the Board of County Commissioners. Because remember, at protest, it's your value, and technically your client is the treasurer because your report is the tax warrant roll. Once the County Board of Equalization renders their decision, that value then becomes theirs. So at the third level, as Greg said, whenever you are presenting at that third level, you are defending the commissioner's value because they are the ones who have made that determination. Okay? So they then become your client. Intended users for your information, obviously it would be your boss, the assessor, could be taxing entities because they have to set their budgets for their mill levies. Clearly, my office and my boss, the property tax administrator, the auditor, uses that information to test to make sure that you're doing your job correctly. When you go to BAA district court or arbitration, are standards 1 and 2 required? You can use standards 5 and 6. It's just generally not recommended. Okay? Now it's CBOE. Do you look at standards 1 and 2 or 5 and 6? Typically speaking, 5 and 6 is what you're using at CBOE because at the county board, what you're doing is you're defending the value that came out of the mass appraisal model. And one other piece about our mass appraisal standard, Advisory Opinion 32, which is the mass appraisal advisory opinion. If you haven't read it, I tell everybody who takes the USPAP class that you should. It's got good information. It states in part, if an appraiser communicates mass appraisal results for a single property, it must be meaningful and not misleading. So again, that means that your model got everything perfect and that you can defend that value with what the model statistically calculated with your variables. So our quick trip through USPAP, the ethics rule, as part of the conduct section, you must perform assignments ethically and competently. You must perform assignments with independence, impartiality, and objectiveness. You must not advocate for the cause or interest of any party. You must not communicate an assignment or assignment results that is misleading or in a fraudulent manner. Hopefully this is all USPAP review for you. The record keeping rule, you must have a work file, must be in existence prior to any report, and a written summary of any oral report must be added to the work file within a reasonable time after making an oral report. Your work file must also include your name of the client, true copies of any written reports. When we say true copies, what does that mean? Very good. It must have a signed and dated certification. That is a true copy. And they made that distinction because people were filling out their appraisals, they were Xeroxing them, throwing it in the file, and then signing it and sending it to their client. That's not a true copy. You have to sign and date your certification with the one that's in your work file as well. Summary of all oral reports also include a signed and dated certification for your oral reports. Any of your other data, information, or documentation to support your conclusions, and you must have custody or retrieval agreements if you are working for somebody else for another owner of, say, an appraisal shop. All right, so record keeping. So part of our record keeping, the Colorado Revised Statutes have said that 3 working days prior to any hearing, the assessor, upon written request, is required to make available to the taxpayer all data supporting the property valuation. So have any of you got any of these requests before in protests?
Yes.
Okay, yeah, a few of you. The information that they're looking for is they want to see everything how you came up with the value. Your CAMA models are proprietary to your CAMA vendor. So you do not give them your model and how all of that stuff worked. What you can give them is all of your sales that have taken place in the area that were used to establish that value. But you cannot give them the model information because that is proprietary to your vendor. The other thing is if there's any confidential data that was used, you must make sure to redact all of that so that you're not giving out any confidential data to those taxpayers. So then we have scope of work rule on page 11. Remember, after you've identified your problem to be solved, your scope of work is determining all those things that are necessary to develop credible assignment results, and you have to disclose this scope of work in your report. Speaking of appraisal peers, we asked this question a little earlier. What are the two things that make someone an appraisal peer? Do you know? Do you remember from class?
Knowledge and skills.
Good. It's expertise and competency per assignment. So I may be an appraisal peer with Joel when it comes to valuing an office building, because I've valued office buildings for a long time now. Joel and Jim may be appraisal peers because they've both done commercial valuation for a very long time. I might not be an appraisal peer with Don because Don has done high-rise offices in downtown Denver, or he's valued restaurants in downtown Denver, just as an example, and I've never done that. So even though Don and I have been in the business a very long time, we're both certified generals, if we get an assignment to value a restaurant, we may not be appraisal peers because I don't have the same level of expertise that Don does. So you can be an appraisal peer in some assignments and not in others. It is assignment specific. And the two words are expertise and competency. When we're talking about our standards, an opening statement for a standard 1 appraisal development, in developing a real property appraisal, an appraiser must identify the problem to be solved, determine the scope of work necessary to solve that problem, and correctly complete the research and analyses necessary to produce a credible appraisal. The report for your standard 1 appraisal in part says when you're reporting the results of a real property appraisal, you must communicate each analysis, opinion, and a conclusion in a manner that is not misleading. So, statements about your appraisal and your appraisal report, good statements to have when you are presenting those reports in an appeal hearing. In a comment to Standard 2, which is really important, Standard 2 doesn't dictate the form, format, or style of your reports. What it does dictate is the content of the report. That is what determines its compliance. So your format can be however. As we said, for example, you have to disclose your scope of work. You could have on a page scope of work underlined and a paragraph explaining all of that. You could have that. Or you could just have all of your analysis and your conclusions throughout the report narrative. It's clearly disclosed. You haven't isolated it in a paragraph, but you have put it throughout the report. That's still in compliance. Make sense? So format isn't the issue. It's the content which gets you in compliance. And then at the bottom of 11, we have our opening for our standard 5. In developing a mass appraisal, an appraiser must be aware of and understand and correctly employ those recognized methods and techniques necessary to produce and communicate credible mass appraisals. One other thing we have to have on page 12, we have to have our certification. And both standards 2 and 6 require that each one of your reports contained a signed certification. That's at least similar to the example we've provided here on page 12. So, quick comment before we go through the example. This certification is not intended to disturb an elected or appointed assessor's work plans or oaths of office. Assigned certification is an integral part of an appraisal report. An appraiser who signs any part of a report must also sign the certification. So this isn't trying to be onerous to your duties, but this is a requirement of your office. On page 12, the example certification includes the requisite language that discloses valuation services within a 3-year period preceding acceptance of the assignment. The employees of, insert county name here, have performed multiple valuation services for properties subject to this report within the 3-year period immediately preceding acceptance of this assignment. These services include normal course of business activities within the work assignments of the assessor's office, and include, but are not limited to, property inspection, property measurement, sales confirmation, updating of inventory, highest and best use analysis, and valuation review for appeals. As long as you have that in your signed certification, you'll be fine. Because if you think about it, USPAP requires the review of have you done any work in the 3 years prior? Absolutely. You essentially look at all of your properties every year, don't you? In essence. So it's good to have that statement, and it's necessary to have that statement in there so any property you come across, you won't be in violation of that part of the certification for USPAP. And then finally, our conclusion. How can I translate my mass appraisal assignment conclusions into credible testimony in conformance with USPAP? And it says, let's discuss. Laura's going to talk to you a little bit about the presentation and testimony part. The answer to this discussion is just follow USPAP and all of the legal rules we've been talking about for the past couple hours, right? As long as you do that, you'll be fine and you'll be in compliance.
Throughout these next couple of sections, you have in your materials that we sent with you with your outline, these reference materials. We're not going to pull them out and talk about them specifically. They are more just for you when you get ready to sit down to do a hearing. They're good things for you to look at and go through. So they're checklists, reading materials, the 10 Commandments of Cross, which I really like because it's just 10 really short things for you to think about when you're getting ready to testify, when you're getting ready to go to court. There's some terminology, and then the 5th one in the reference materials is from the AG's office. It's on unpublished decisions. So some of the case law that is listed in the back of our case law section, some of them, a couple of them are unpublished. So we have an AG opinion on how we use unpublished decisions. So preparation. This is a picture. How many of you remember the landing in the river in Washington, D.C., and Sully, who landed that plane? How often do you think he's ever done that? Zero. But he did some stuff ahead of time in his training to prepare. That helped him land the plane in the river. I love this quote from Steve Foster with my Colorado Rockies. I'm a Rockies fan. I'm a baseball fan. The pitching coach says, preparation prevents panic. So how many of you have the time to prepare before you go to BAA? You have to take the time to prepare, because if you don't, you're going to get up in front of the board and not be able to find exhibits, not be able to think of what you're going to say. So you've got to prepare. So that preparation starts, you are an expert witness. So as an expert witness, you need education. That's what you're all doing here today. You have to guide the Board of Assessment Appeals or district court through your appraisal report and guide them to the value you want them to conclude to. That's part of your job as being an expert witness. And also you're a salesman, saleswoman, salesperson. You have to sell them that this is the best value for this property. You need to know the territory. There should be nobody in that BAA hearing room that knows your property better than you do, and knows your territory and knows your county. So the taxpayer knows his or her property. They probably know how much square footage it is, what quality and condition it has, etc. But you are the expert witness. You know the local factors. You know the true comparables. And you should know information from the internet. How many of you search the internet when you're looking, when you're getting ready for a hearing? Sometimes that's the best place. Or MLS, what is the property selling for now? You can't use it in your appraisal, but it gives you an idea of a value. The next thing you need to start preparing for, what are the objectives in your testimony? What's the dispute? Now, we have court case law that says you can't pull the components apart, but what's the land value? What's the improvement value? Is there economic obsolescence? Sometimes counties will stipulate the only thing we're here to talk about is depreciation or obsolescence. We're not going to talk about the whole value of the property because that's not an issue. All we want is depreciation, or a bigger factor is the cap rate. In a commercial property, a cap rate can make a huge difference in value. So what are the things that we want to focus on in our testimony? So your outline lists some witnesses. There's a theory witness, a primary witness, a backup, factual. Most counties only have one witness. That's the appraiser. Sometimes, as Kyle talks about, he has been called as a witness for what's in our ARL Volume 3. Michael and Ken Beezer have been called for ARL Volume 5. I've been called for abatements or ARL Volume 2. So the division can be an expert witness for you. As we talked earlier, Kurt Settle has been called in some commercial cases. So most of the time you only have one, but you may want to shore up your witnesses if you've got a really big, complicated problem. And I can't stress enough, work and rework your appraisal report. Sometimes you've looked at it often enough that you don't see the grammar or the punctuation or the misspellings. Make sure you have somebody else in your office take a look at that report and make sure that you've gotten rid of all of those things. Outdated materials, check your calculations, make sure that it's correct. Because there's nothing more embarrassing, and it's happened to me, to get up on the stand and find a mistake or have the opposing counsel point out a mistake in your appraisal report. So make sure that you look at that and have somebody else look at it as well. Make sure you're checking your log and your information. Make sure you've verified the sales. Make sure you've got your telephone calls in your work file, questionnaires. How many of you, when you have comparable properties, how many of you go out and physically inspect the comps? Do all of you? You should. because you have to know they're comparable. The only way you can know they're comparable is to get out and take a look at them. Review the comps you didn't use. Why are they not comparable? Because if the values are lower, guess where they're going to show up? In your opponent's appraisal. So you need to know why you didn't use certain comps in your appraiser. And then prepare as a reviewer. Support your own expertise. So if you're taking on an assignment that you're not comfortable with, read some books, take a class, talk to a senior appraiser in your office, shore up your own expertise so that you know when you get on the stand, you know what you're going to say and you know why you're going to say it. That's the most important part. Remember, Kyle talked about being credible as USPAP, so we need to be credible. As a witness, you have to be credible. You have to be knowledgeable. Prepare visual aids when possible. So here are some, this is not in your outline, here are some actual pictures of things submitted to the Board of Assessment Appeals as exhibits. This apparently is the subject property. Quite honestly, some of these are dated. They're old. But somebody took a picture from their paper file, Xeroxed it, and put it into the report. So this is a little bit better. So here's the subject in a subdivision plat. Looks like a sales grid, handwritten. Again, these are dated, these are old. I hope nobody submits this anymore. I love this one. It's a great example of something not to do. So this is a Marshall and Swift book. And somebody's, handwritten some calculations on this page. This is even betterer. Now we're starting to get some more sophistication in our exhibits and getting things that look probably more like what's being submitted now. So obviously that's not here. That's somewhere that California that has palm trees, or Las Vegas, Florida. Yeah, houses with pools. So one of the things that you really need to think about and concentrate on is coordinating all of your witness testimony. If you have more than one witness, you want to make sure that everybody talks to one another. I can't tell you how many meetings we had over the rare air case. We were meeting monthly with our attorney and coordinating what was going to be said. It is a team effort. One of the most important pieces is to prepare with your attorney. So when I worked at Elbert County as the assessor, we had very little time with our county attorney because he was on a retainer and he just wasn't around. So it got very hard to get ready to go to the BAA. Unlike my AG, Attorney General people, when I was here at the division, we had meetings all the time and prepared with those attorneys. And my attorney walked me through what he wanted me to say and exactly the process he wanted me to go through. Once we got that down through 2 or 3 hearings, then it was pretty much just a piece of cake. You just do it the same way every time. But you need to be organized, and your attorney needs to know what you're going to say. He's going to know, she's going to know the best path to get you to success. So you need to practice and talk about Direct examination. So direct examination is when your attorney asks you questions. Cross-examination is when the opposing attorney gets to ask you questions. Those you always want to be more careful of. Cross-examination. And then redirect is after both of those two things have happened. So we're going to first prepare this checklist, and then you want to start talking with your attorney. Practice how you're going to ask and answer those questions so that your attorney knows exactly what you're going to say and how you're going to say it. If you haven't ever been to the BAA, go visit. Go sit in the back of the room and watch a hearing. Because you learn a lot just by watching other people present and other people testify. So check the hearing room. Where are you going to sit in the room? Is the room hot or cold? In this building, you never know what the temperature is going to be. I always suggest to people you dress in layers because you have to take stuff off or put stuff on. Another important piece of your preparation is when, for the BAA, you exchange information. It's called Rule 11. You exchange information 10 days prior to hearing. That is your chance to look at your opponent's case. Look at the appraisal. What comps is your opponent using? Are there typos? Are there grammatical errors? You don't want to call them and say, hey, I found an error in your report. But one thing you do want to do, check all the calculations. I can't tell you how many reports I got as county assessor, and you look at the appraisal report, and you kind of go through those adjustments, the sales adjustments, up or down. Kyle has a special way that he teaches, how you adjust the value up or down. The adjustments were wrong. They had the wrong sign. They were positive when they should have been negative, or negative when they should have been positive. Check those calculations. And lo and behold, I remember one specifically, you fix the calculations, and that value came right into mine. Exactly what my appraisal said. So check the calculations, make sure it's correct. Look at all of the theories and all of the approaches to value. Does your opponent placing more emphasis on an income approach and you're using sales analysis? You want to know that and be prepared because your testimony is going to need to refute that. The income approach is not the best approach to use, and here's why. And the last thing that you want to do is look at your opponent's comparable sales. If you haven't already physically inspected it, go out and look at it. And maybe just before hearing, you want to go out and look at all the comparables again. Maybe something's changed, or maybe you missed something the first time around. So make sure that you really get down, dig deep into your opponent's appraisal. And then, as I said, prepare to explain differences in an approach or a theory, conclusions, comparables, capitalization factors. Oh my gosh. As I said, there have been BAA cases that have focused only on the cap rate. Everything else is step 2. They focus only on the cap rate and any depreciation approach that's used. Maybe you don't think economic obsolescence is applicable. So make sure that everything you need to talk about is up there. And then again, review that with your attorney. Always make sure you have your attorney's ear for at least a little bit of time so that you can talk about your opponent's appraisal, because that's a big part of your case, is to tear apart the other side. You need to defend your value, but anytime you can find a hole in the other side's appraisal or the other side's testimony, that gives you a leg up and gives you an opportunity to win. So, preparation. You play the way you practice. I'm so amazed at baseball players and how much time they spend practicing. Nolan Arenado is in the ball field before anybody else, shagging one-handed catches without his glove. Amazing to me how much time they prepare. Any sports figure, you need to take that same approach. You've got to prepare yourself and your appraisal. Chapter 3, presentation. So you've done all of this prep work, getting yourself ready to testify, getting your report ready, getting ready to head to court. Now you're going to be a witness. So we're going to talk about your demeanor as a witness. Remember, Kyle talked a lot about in USPAP of being credible, expert and credible. This is where your credibility really comes out. You've got to sell not only yourself and your expertise and your knowledge, but you've got to sell your value. So this is a definition of an expert witness: qualified by knowledge, skill, experience, training, or education to provide a scientific, technical, or other specialized opinion about the evidence or the fact issue. This comes out of the dictionary. So that's what an expert witness is. So you need to try to get yourself prepared to do all of that so that when you present, you're credible. So avoid distracting mannerisms. So don't sit at the podium and tap your pencil. 2 reasons. First of all, it ends up in all the sound equipment. So everything that gets recorded at the BAA gets recorded, and they're going to hear you tapping your pencil on the table. And it's hard for the board members to pay attention to you anyway. And if you are distracting, then they're not going to be listening to what you're saying. Speak clearly, concisely, and be confident. Remember, you've prepared for this. This is your time to shine. Always be serious and courteous. Look at the board. It's hard for them to ignore you or fall asleep when you're looking at them. Okay? So, presentation without preparation is futile, but the best preparation can fall victim to poor presentation. So, you can have an awesome appraisal report. You spent hours and hours and hours on your appraisal report. But if you get up in front of the BAA and can't remember what's in there, or worse, don't have things marked so that you can find them, it's going to fall flat. Never argue with the opposing attorney. As silly as that sounds, losing your temper only undermines your testimony and your credibility. You need to keep your cool. Always look at the board. Address your answers to the board. Your attorney knows your answers. You don't need to be looking at him or her. You need to be looking at the board. Address the board. Always make sure you understand the question. Always pause. And that's one of the things that your attorney will tell you. You want to do that 5-second rule in case your attorney wants to object. So make sure you kind of pause a little bit, think about the question, think about your answer before you open your mouth. You want to make sure that that answer is credible also. Practice, practice, practice. If you can't get in front of your attorney, practice in front of a mirror. That helps you get an idea of what you look like when you're saying stuff. Makes a big difference. You need to be credible. You need to be prepared. So, and get ready to point out the strengths and recognize the weaknesses in your case. No case is perfect. And you know better than anybody what those weaknesses are. Make sure you're prepared to answer the weakness with a strength. Make sure that you can tell the board why you used the income approach as opposed to the cost approach, why you used one comparable over another. Videotape it and then rehearse. Rehearse with, if you can't get in front of your attorney, get in front of a coworker and rehearse questions and answers with somebody who's been there. And I've said this a couple different times, be organized. So in your report, make sure you've got some tabs and some dividers so that you can get to things quickly. Because what happens during testimony is that you could get started down the path of your appraisal report and the opposing attorney objects, or the board asks a question. And if the board asks a question, you kind of have to answer. So that might derail you as to how you're going through your report. So make sure it's organized. On cross-examination, you might have to go back to something. So on cross-examination, the whole purpose of cross is to discredit you. You, maybe personally as a professional, but certainly your testimony, certainly your appraisal report. So that's the whole purpose of cross-examination. And again, practicing with your attorney, what kinds of questions do you think are going to be asked? Remember, your opponent has gone through your appraisal just like you've gone through theirs. And so you know your weaknesses. We talked about that a couple slides ago. You know the weaknesses better than anybody. Be prepared to answer those because that's what they're going to pick out. That's what they're going to find. So be alert. Everybody likes alerts. Try not to help the opposing counsel. Don't volunteer stuff that you're not asked about. Don't volunteer. Leading questions are permitted in cross-examination. Also, remember in the back of your head, are there skeletons in your closet? We all have them. Was there a prior appraisal report on this property? Did this property go to the BAA before? And if so, what was the conclusion of value in that appraisal report? And why is yours different? Make sure you know all of those things before you get on the stand. Admit you don't know something when you don't know something. Don't try to skirt it. Don't try to lie about it. Don't try to make something up, because all of that will come back and bite you. So make sure you say, if the opposing attorney asks you something you don't know, say, hey, I don't know that, but I'd be happy to look it up and get back to you. Subject to check is something that I've never been involved with, but it is something that attorneys will do. Say subject to check. If a question is ever posed to you that way, make sure you check it. Make sure you go back and check your material as well as all of your supporting documentation, and make sure you've checked out any of those things. Be brief and answer one question at a time. And look out for compound questions, because sometimes attorneys will try to flip you up by asking you a compound question, which means it's two questions in one. You can't answer yes to both halves. You can only answer yes to one half and no to the other half of the question. So make sure that you understand the question and stop and say, hey, attorney, Mr. Attorney, I don't understand the question. Could you please rephrase that for me? I don't understand the question. No tentative answers. Again, you need to be positive. You need to be honest. So I pulled off the internet this picture of Lady Gaga, because this is not the way you want to go into a BAA hearing. This is not. So there's 100,000 Law and Order professional things on TV, so you know what professional people look like. You know what lawyers look like. You know what Kyle looks like. Kyle always has a tie when he teaches and a coat. You need to look like you're serious, and you need to look like you are a professional, because you are. And dress makes you feel that way. Some people disagree with me, but Kyle always has a coat and tie whenever he teaches. Not everybody does, but that's Kyle's style. Preservation. So, we've prepared our report, we've testified at the BAA. Now we're going to talk about some of the things that we also want to have in play to preserve our record. Because remember, everything you say is recorded. Everything you present as evidence is of the record. And this is important. Why? Those of you that have taken assessment appeals, why is this important? What happens to this case on appeal? On appeal, they look back at the record. That's all they can look at. There is no more testimony. There is briefing from your attorneys. But what you do, what you say, what you present, how you present it at the BAA is called the record. And when it goes up to the next level, to that third level of appeals, to the Court of Appeals, the record goes. You don't get to go testify again. You're done. So it's the record that goes up. So we need to preserve it. So the record of the court. And again, through your testimony, through your appraisal report, you need to be clear and concise. One thing that I always started with when I got on the stand was to say my name and spell it. Spell my last name. Even though Forbes, like the magazine, not related, is easy enough, but sometimes your name might be enough that you want to spell it for the court, or at least have your business card there. Pronounce and spell your name. The record will contain everything that is spoken and written. Nothing will be in the record unless you present it. So you can have the greatest appraisal report in the world, but if for some reason, somehow, one of your exhibits does not get admitted to the court, it's not going to go up if that case is appealed. So organize, we talked a little bit about this before, organize your report in a sequence. You want a description of the area, the neighborhood. You want a description of the property. You need to determine land and improvement values. You want your cost approach, your market approach, your income approach. You need a reconciliation, and you need a final estimate of value. Number all of the pages. I remember the first time I prepared a report to go to the BAA with my attorney from the Attorney General's office, he said, "Laura, would you please number the pages for me?" I don't want to number the pages. Number the pages. Because if you are interrupted, you can retrace your steps and go back to page 5. Start over if you have to. Number the pages. And don't shortchange yourself. So the BAA sets a time frame, a time slot for your hearing. And the petitioner always goes first. So hopefully the board is paying enough attention to the time so that the petitioner, if the hearing is set for 2 hours, the petitioner gets 1 hour, not an hour and a half, not an hour and 20 minutes. You should get equal time. So don't shortchange yourself. Make sure that you get everything you need to say in the record, because that's what's going up. I always try to prepare myself and my case as if it were going up to the Court of Appeals. You've got to think that way. So make sure you clearly label your exhibits. So not only did I have to number all those dang pages, I had to put exhibits labels on all my exhibits. This is exhibit A, this is B, this is C. Clearly label them with some sort of systematic, and always try to get into the habit of referring to, this is exhibit A. Exhibit A is the picture of this $2.6 million hangar. Refer to that in your testimony, because remember, if this goes up to the Court of Appeals, the judge at the Court of Appeals is not going to be able to follow your testimony because you have not identified what you're talking about, where you're talking in your report. So that's why page numbers and exhibit labels are important, because somebody is going to read your testimony. If it goes up to the Court of Appeals, a judge in a little black robe is going to sit there and read every word you've said. So you need to make sure that judge can follow you where you are in your report. So in 2012, effective in 2013, the BAA started a new procedure called summary judgments. You can have an either full decision or a summary decision. I think the idea here was they were trying to get rid of some backlog and being able to get decisions out faster. A summary decision is way faster to produce than a full-blown decision. Only the full decision could be appealed to the Court of Appeals. A summary decision could not. And both parties needed to be agreeable to the summary decision. Now, having said that, I have not heard of anybody who's actually used it. They've all been full decisions. So there is that option. Whether they use it or not, I don't know. But from what I've heard, not many people, not anybody has used it. So in summary, the appellate court is going to base its decision on the facts and the conclusions of law, old case law, etc. So you, as the appraiser, have no control over their decision, but you have complete control of how it gets into the record. And if you don't take control of it, it could get out of whack, and you may not get the decision you want. Case law. So what I've done for these cases that I've got slides for, I have made the most important point of the case in yellow. So if you want to write it in the margin or highlight it in your text, would help in case you go back. I know I've done that with some of my other case law indexes where I've written in the margin what the case is about, so that when I need to go back and find, okay, which case did this, I can find it more easily. So this is the first case we're going to talk about. It's out of Denver, and it is awesome. The name of it is Thibodeau versus Denver. It was an intervening year issue. So the assessor, in confirming sales from 2012, found out, discovered, somehow realized through the MLS that this property had been remodeled. Had been remodeled in 2012. And the assessor's office had missed the building permit. And so they had valued the property in 2013 as if nothing had been done. In 2014 is when they discovered they had missed the building permit. And there was some substantial remodeling done to the house. They had remodeled the kitchen, they had replaced all of the plumbing, they had done a lot of improvements to the house, much to the distress of the taxpayer, but because the assessor raised the value in 2014 to reflect the remodel and to reflect a change in the quality, because this now had a gourmet kitchen and all new plumbing and water and heat. And so the assessor changed the quality grade to reflect the remodel. The Court of Appeals upheld the county's value and said, in an intervening year, there are 3 reasons why you can change the value: to correct a clerical error, to account for an unusual condition, or to correct an incorrect value. And I have told assessors for years that if you find an error, you can't send out a special NOV to correct an undervaluation. But you can correct that undervaluation the next year to get it to the correct level of value. Because a special NOV is only for omitted property. You cannot fix an error. Once you send out that notice of value, there are 2 ways to change the value. If the taxpayer protests, or if you take it to the County Board of Equalization. Your County Board of Equalization can correct an error, but most assessors are very reluctant to take it to the County Board and raise a value. Several times I had to. One year we missed a discount on a subdivision. We had the wrong discount rate, and so we fixed it and it raised the value. Another year my ag values were out of compliance, so I had to go to the board and raise all of my grazing land. Very popular that year I was. But the county board did it. And that's their job as County Board of Equalization, is to fix errors. So you can, assessors, you gotta eat it the first year. But the second year, you can fix it. Get it to its correct level of value. I love this case.
Laura,
Sir.
we had, I a typo in one of our models for restaurant properties and overvalued restaurants by 30–40%. And we didn't find out about this error until people started protesting. And it was the county's fault.
Right.
Is there a way that we can blanket change all of those properties? Because what we've been told is, no, we have to wait till they protest. Well, a lot of people don't protest because they don't know any different. But if we know that there was an error made on our part, is there any way that we can blanket change all those property values?
Are you lowering the values?
Yes, lowering.
So some counties will process a blanket abatement for all properties not protested. You can always lower values. It's raising values that is troublesome.
Oh, of course.
We have court cases that say you can't. But yes, you can always lower values. Oxy is an abatement case, oil and gas abatement case, and there was some old court case law out there that said a taxpayer cannot file an abatement to fix its own created taxpayer error. And the county denied this. And it went all the way to the Supreme Court. And the Supreme Court said, yes, a taxpayer can file an abatement to fix a misreporting on the taxpayer's part. So yes, you can fix an error when the taxpayer makes the error. Traer Creek is a recent one that has brought up a lot of controversy, so to speak. So it's standing for the lessee. So if you read the case, it's very interesting. A lessee of a commercial property walked in to file a protest. And he didn't have much more than something scribbled on the back of a napkin. And the assessor denied the protest. Went all the way up to court. And the court said, a mere lessee has no standing. So, must have proper authority. And I think that goes back to when you start looking at protests, you've got to have the person standing in front of you to protest has to have standing. You can't just take a protest from anyone who walks in the door. You want to make sure it's the owner or the owner's agent in front of you. Because otherwise, you are thwarting the correct property owner's rights. So you need to make sure everybody has standing. Kinder Morgan is another oil and gas. So I like this case as well. Kinder Morgan was audited. The county assessor went out and audited the books of the oil and gas company. And when they did that, they found some misreported expenses. As a result of that audit, it increased the value of the taxpayer, of the production of the oil and gas. And so the assessor sent out special NOVs for omitted property. And the taxpayer argued this is not omitted property, it's omitted value. So Village at Treehouse is another really great case. So this HOA had some development rights that it sold to a developer, and it sold for $1 million. That deed came across the assessor's desk, and the assessor says, taxable property. Taxpayer said, no, this is just development rights. This isn't real property. This is just development rights. Well, the Court of Appeals disagreed. The Court of Appeals ruled that development rights are real property. and they should be taxed. Roaring Fork, top of page 2. So Roaring Fork was a golf course decision. In our manuals, we instructed assessors to use all memberships, sold and unsold, as part of the valuation process and capitalize it into a present worth, present value. But here again, the court came in and said, no, those sold memberships are not real property. They should not be included in the valuation process. So we had to change our manuals for golf course. CTS investments out of Garfield County. Very important case. The assessor's value was $30,000 an acre. The taxpayer paid $2,200 an acre. What value do you think the taxpayer wanted on his property? $2,200 an acre. And so through the presentation and the appraisal report, the assessor proved to the BAA and the courts that this transaction where the taxpayer purchased it for $2,200 an acre was not an arm's length transaction. And remember that all of our data, all of our sales have to be, that's one of the things, it has to be an arm's length transaction. So the assessor approved that this sale was not an arm's length transaction. And so they denied the appeal. Another case out of Eagle County, Bachelor Gulch. So Bachelor Gulch was something that changed in an intervening year. And in an intervening year, if there is no unusual condition or if it's not at the correct level of value or there's an error, you have to keep the same value of the property in that intervening year. So in the intervening year, or in 2007, the hotel converted to condos. So in 2008, the intervening year, the assessor had to leave the same value on the property and went through an allocation method to allocate dollars value to each of the condos as well as the remaining hotel. Now, I looked at the case, truth be told, the majority of the value stayed in the value of the hotel because the condos on a square foot basis didn't amount to all that much. So the taxpayer appealed. Why did the taxpayer appeal?
Res rate.
Res rate, exactly. The res rate. So the condos got the res rate. The hotel didn't. So the hotel's tax bill didn't change by much. Lowered some, but didn't change by much. So here's another affirmation. County assessor, you have to use our manuals. You have to pay attention to what's in our manuals. And the court found that the allocation method was in the manual and the assessor applied it properly. Jet Black. This case was so complicated I needed 2 slides for it. So Jet Black out of Routt County. So this was 793 acres with a conservation easement on it. So first of all, those of you that know anything about ag conservation easements, forever, that 793 acres is valued at ag. Those lots were selling for $2.5 to $3 million a piece. So that's what the property owner, he had ag value. So he could pay whatever he wanted. Well, then in addition to that, the HOA spent $4.8 million with an M to construct common improvements. So this is a homeowners association owned by, so common area, spent $4.8 million. So we had pole barns, we had guest houses, and this great big lodge where they had parties and all exclusive use of the homeowners, but $4.8 million. So the county assessor valued all of those common elements and assigned $17.5 million, because that's totally what was spent, to each lot. Because why? In a homeowners association, in common elements, are the common elements valued separately? No, because they're considered to be in the market value of each condo or each lot or each house in the homeowners association. But this property had an ag lease on it, or had an ag conservation lease on it. Were the common elements included in the value of that ag land? No, they were not. So the assessor extracted them and assigned them to each lot. They were not happy. So they went to court. And the court ruled, because the value of the common elements were not in the value of the ag land, the assessor had to add them, and added them as omitted property. So those elements are valued and valuable and assigned to each lot. Okay, CP and Sons. We're at the top of page 3. So CP and Sons is a case out of Boulder where the taxpayer paid, again, just almost like CTS Investments, paid $19,250 for this property, and the assessor had $34,000 on the land. And the taxpayer said, I only paid $19,000 for it. So of course that's what it's worth. So again, and the taxpayer claimed that the assessor should have to individually value through individual reports the value of every property in the county. The assessor should not be able to use mass appraisal. The assessor should value each property in the county individually. And so the court said, yes, mass appraisal is appropriate. And again, the assessor proved that sale was not arm's length. So that's something that you need to keep in the back of your mind. If the taxpayer has paid an absurd value for this property, a low value for this property, and is claiming, well, of course, this is the value. This is what I paid, so this is the value. You need to get prepared to prove it's not arm's length. And if you can't prove that, then you might have to eat it. You might have to roll. But you need to be able to prove that value is incorrect. Regis Jesuit. So commercial appraisers. We had a commercial property leased by Walmart or Kmart, had a 20-year lease, a long-term lease. And the assessor's office valued it using market lease rent. And the taxpayer said, I'm encumbered by a long-term lease. I can't get market rent. I can't get market lease for this property. It's under a 20-year lease. And they were only like 5 or 6 years into the lease. So the court said, You know what, assessor? You have to look at contract rent. You have to consider it. They remanded it back to the BAA, but you must consider contract rent. That's part of what the court said. BAA versus Sonnenberg. Does anybody recognize this name? Sonnenberg? He's my senator, Senator Sonnenberg, out of the eastern part of the state. His family owns a feedlot in Logan County. At least they did back here, back in this state. So Sonnenberg protested. The county assessor only used the cost approach because she didn't have any sales and she didn't have any income information. So she went to the Board of Assessment Appeals with the cost approach. And the tax agent who represented the Sonnenbergs brought in sales information from, I believe, Nebraska and Kansas, brought in some income information from some other feedlots, and proved that the value was too high in the cost approach. So this gives us permission to look other places other than just in our own backyard. Montrose is kind of the opposite of Sonnenberg, but in a different way. So there were 3 motel properties. The assessor used the cost approach to value that hotel, but he also documented reasons why he didn't use the other 2 approaches, or why they were not as reliable as the cost approach. He prevailed. The BAA ruled in favor of that value. So it's not that you have to use all 3. You remember the law says appropriate consideration of all 3 approaches to value. So you do have to consider them. And if you can't use an approach, document it, and document it well. Fellows versus Grand Junction Sugar equates actual value to market value. Notice the date on that? 1925.
It's almost 100 years old.
It is. It is. Welby Gardens. This was a feather in the cap for the Adams County assessor. We had been fighting greenhouses forever. The court ruled it is not ag. The products, the most important point out of this case is those products need to originate from the productivity of the soil, of the dirt. It has to be planted and harvested and sold. Productivity of the soil. And there's a quote in here from the Supreme Court. So Del Mesa Farms out of Montrose did a couple of things. So it was a chicken operation, and they grew some of the corn that they fed the chickens in the dirt on the property. And so the court, or that was Morning Fresh Farms, and so the court in Del Mesa said, well, of course, this ag operation, that chickens is an ag operation. And so the most important thing that came out of Del Mesa Eggs is it differentiated between the personal property of a building, that's fixtures. So the personal property required to support the building is fixtures. The personal property required to support the business is personal property. So that makes a difference in an ag classification because it's exempt. The fixtures are part of the building and the personal property then is exempt. So Edith Clark, right now in Douglas County, those of you, anybody familiar with Douglas County, there's a place called Clark Farms. Used to be Edith Clark, used to be farm. So the issue concerned whether or not it was agricultural land. These were in several parcels. And what it came down to, so there was testimony that some of it was grazed, some of it was in conservation, or if they, and so the court comes back and says, it's gotta be either or both. But the most important thing, there was such confusing testimony here as to what was being grazed and what was in conservation. And the court was confused as to what was actually happening. They remanded it back and said, you need to prove what's being grazed and what's in conservation and what's not being used. Because the county kept saying it's not being used. There was part of this ground that I think was a polo field. So how is that ag? And that's what I said. It was so confusing that the court finally remanded it back, but with directions. You've got to graze it, or you've got it, it's got to be in conservation, all of it, not just some of it. So of course the testimony changed and was cleared up when it came back. Equalization. This is another one of my very favorite cases. So this is a case out of Arapahoe County. These were two attorneys. They each owned a house. Now look at the date on this case, 1997. Probably their values have doubled or tripled since then, but they were $500,000 houses. Their values in that reappraisal year went up 32% and 46% versus the 10.7% that the overall county values went up. So the Podal brothers compared their increase to the rest of the county, and they said, this is not fair. This is not equal. My house went up 45%. Everything else in the county went up 10%. That's not fair. And the district court lowered it, which is what they expected. They're attorneys. Okay, so they went to district court first. They went to the Court of Appeals, who affirmed it, and then the county appealed it to the Supreme Court. The Supreme Court defined assessment and equalization. Assessment is the act of putting a value on a single property. Equalization is equal values within a class or subclass of property. So individual appeals, like everything else we kind of talked about today, you have to prove the value's wrong. You can't just come in and say, this is not fair. The rest of the county only went up 10.7%. Mine should have done the same. That's equalization. And the court said, no, it's not. That is not equalization. You have to argue the value of your property. So the Supreme Court overturned the lower courts. So Bishop is another equalization property where, again, this was out of Jefferson County. So lots with views increased from $29,000 to $50,000. So they had all of the lots in the subdivision valued the same. And they went out and they said, looked at sales and said, hey, view lots are selling for more dollars than lots that don't have views. And from an appraisal standpoint, does that make sense to you? Okay, condos facing the ski slope sell for way more than condos facing the trees. So the views were supported by sales. Unfortunately, not all of the view lots were caught, and not all of the viewed lots were increased. So the taxpayers who had their value increased came in and said, hey, this is not fair. You are supposed to provide fair and equalized values. And these guys over here have views and their value is still $29,000. And the court said, no, we cannot lower a correctly valued property because something else is incorrectly valued. How many times have you heard that? Well, my neighbor's house is much more betterer than mine, and his is $10,000 lower. Yesterday. And probably again tomorrow. So you cannot lower a correct value to be equalized with an incorrect value. Highest and best use. Two Long brothers. So this was a lot in the corner of the Pearl Street Mall. Anybody familiar with Boulder and the Pearl Street Mall? It had an old tire shop on the corner lot. Corner lot, I want to emphasize again, corner lot. It was used as a flea market. So the owner had flea market stuff going on all the time. The county assessor reviewed this and said, you know what? Land, that corner lot, based on my sales, would sell for $2.26 million. Put a placeholder for the improvements of, I don't know, $1,000. Valued the land at $2.26 million. The petitioner said, hey, that's not fair. You can't value my property as if it's vacant. It's being used as a flea market. And I earned $750K off that flea market. So that's what the property's worth. Court agreed with the assessor. And under the R.L. Berg case, which we're going to talk about next, you can use reasonable future use. Consider the property's highest and best use. And it applies to improved as well as vacant. Similar to an issue where you've got an old homestead in the middle of town, still being used as residential, but everything around it's commercial. So you value it, you assess it as residential, but that value is based on market. So R.L. Berg is similar. It was a property in Winter Park. It was a piece of vacant land that the assessor, it was undeveloped, but she valued it like based on sales that would support condos. That's what was going in all around it, was condos. So that's what she used to value the land. And the property owner, of course, came in and said, you can't value, that's too high. You can't value it like that. We don't know what's going to be there. Well, the Supreme Court said you can use reasonable, not speculative, but reasonable future use to value that property. Intervening year, Carrera Place. So top of page 7. So Kyle talked a little bit earlier about things that change after the appraisal date. So Carrera Place is a case that supports and upholds that appraisal date. And so this is way back when, but our economy in Colorado has done a roller coaster over years. And so back then, their property was valued on an economic growth period or an economic stable period, and then the bottom fell out, like happens. It's happened 2 or 3 times. And so the taxpayer came in and said, I can't sell my property for that right now. The economic conditions have dropped and I can't sell my property for that. And the court said, we don't care. Economic factors outside the base period are not considered until the next data gathering period. So here is our omitted property. So Marsico is another Denver County case. It was tenant finish that was missed for prior years. So the assessor's office went back and added it through special NOVs. It was omitted. And the court agreed, yes, that tenant finish is omitted property. It's real property. It's omitted. Unlike in Stitches. In Stitches was an embroidery company that had these fancy dancy embroidery machines worth a lot of money. And they didn't file, and they didn't file, and they didn't file. And so the assessor's office kept applying BIA assessments. They finally got in to audit the property and said, whoa, we undervalued this. We severely undervalued this. We did not guess correctly. And the court said, as a BIA assessment, that value has to stand. That is undervaluation, and as such, it is not omitted property. It is omitted value. So you see the difference between our tenant finish, which you can feel, touch, look at, measure, and our in Stitches. We have created this value that is intrinsic. It's a guess. It's a dartboard. It's a, you guys know what a BIA value is. You make your best guess at it. But if you guess wrong and it's undervalued, you can't fix it. If you guess wrong and it's overvalued, you can't fix it. A minute. Cantina Grill is another one out of Denver. It's at the airport. It's concessionaire. Taxpayer contended that because there were all kinds of other restaurants in Denver Airport, they were not PI. And the court said, oh, yes, you are. You are possessory interest. And they laid out this 5-step process, 5-step test for possessory interest. That's our most recent PI case. This is another favorite case of mine, Eagle versus Vail. So back in 1988, the legislature, in its infinite wisdom, decided that it was going to exempt possessory interest. And that as the legislature, it could exempt whatever it wanted to. So they were going to exempt possessory interest for ski areas. And the court ruled yet again, it took until 2002 to fix it. Legislature, you can't exempt property. Only the Constitution can exempt property. And oh, P.S. and by the way, agricultural leases taxable as well. Ag leases on state property or federal property. So this was my renegade assessor buddies. State board told them to exempt the possessory interest, and my renegade assessor buddy said, no. So, love this case. And this is probably one of the very first possessory interest cases is out of Mesa Verde. So Mesa Verde is a campground, national park campground. And so there was a campground owner outside of Mesa Verde that, of course, paid property taxes. There was a campground inside Mesa Verde that did not pay property taxes because it was on federal ground. And the guy who owned the campground outside of Mesa Verde said, that's not fair. He has more overhead than I do. And the court agreed. When public property is leased from an exempt entity and used to produce a profit, it's taxable just as if you owned it. So that goes back to, how old is Mesa Verde? 1995. Actually, the first one I think was clear back in 72. Okay, present worth discounting. This is out of El Paso County. We had some really bad Court of Appeals case law on vacant land discounting. And the Court of Appeals basically told us you have to apply vacant land discounting to every piece of vacant land in the state of Colorado. And El Paso County finally had a really good case, went up with it, and they won. So the Court of Appeals ruled in Craddock that the assessor has the discretion as to whether or not discounting is allowed. So it's the assessor's determination on discounting, whether or not it's applied. Farney, out of Dolores County. Farney was an old cabin, had no running water, had no flush toilets, but was owned by a taxpayer that testified he and friends came up and stayed in that cabin 25 days a year. The assessor had reclassified it as vacant land with a minor structure. And the taxpayer said, oh, no, this is res. We come up and we stay here. We sleep here. The BAA ruled it was residential. And I love this quote out of the case. There was no proof that any other classification was justified. So the county did not substantiate vacant land. Again, proving your case. ER South Tech. I remember when this case came down, we all kind of rolled our eyes, trying to figure out what in the heck this meant. So this was a hotel that was used for some of the rooms as long-term rentals. And the owner had sales tax revenue to prove it. And so the court ruled that's a mixed-use property. You've got some of the rooms as hotel and some of the rooms rented on long-term basis, like an apartment. Should be treated like an apartment. And so I've had, but again, the point here being is that the taxpayer proved it. So I've had counties call me and say, Laura, I've got a hotel, and they say they're using it for long-term rental. Can they prove it? Do they have sales tax receipts? Do they have some sort of documentation to prove that this should be partially residential. You can't just walk in and say, I'm residential, any more than you can walk in and say, my value should be $2,200 an acre. You've got to prove it. So this is a great case for that mixed split use. So Manor Vale, this was a case where the homeowners association owned a building that was used as a restaurant, and it was used to outside people. It was not just homeowners. So homeowners association property is supposed to be used for the homeowners. That's part of the intrinsic value of the value of their lots. So this one was not. And so the county assessor pulled that restaurant out, valued it, assessed it at 29%, because after all, it's commercial property. So it's 29%, and then allocated that value to each homeowner. Because each homeowner benefited from that restaurant being in their community. And the court affirmed the assessor's allocation, just like we saw in the other Eagle County case. And again, volume 3, assessors, you need to use our manuals. Again, affirmed that using the assessor's reference library. And I love this one. This is an old one too. But in order for it to be residential property, you gotta have a dwelling. So this was property where the developers had come in, they had put in streets, they had put in gutters, they had put in lights, they had put in water, sewer, blah, blah, blah. And they thought they needed the residential assessment rate on that vacant land. And the court said, no, you have to have a dwelling. That's what the Constitution says, with residential improvements. So here's our Sampson case. We've kind of beat this to death, so we won't go over it. Only that the taxpayer has to prove the value is incorrect. Taxpayer doesn't have to give you a value, say what it's worth, but the taxpayer has to prove the value was incorrect. I love this case too. Taxpayer came in to protest to my dear friend Peggy Cantor in San Miguel County, and Peggy found an error in the valuation. And guess what? She fixed it. She raised the value. And the taxpayer said, oh, no, you can't do that. I came in to lower the value of my property. You can't raise it. Well, the Supreme Court said, yes, you can. As the assessor's duty, you have the statutory authority to raise, lower, or adjust as you see fit. And then Cherney. So Cherney came in to protest. He liked the land value, but he didn't like the improvement value. And so the court said, so statutes only speak to valuation of assessment. It's absent on how to appeal for the value. But the court said you have to seek the total value of the property. We're not going to split hairs and split it apart. Because I think there are counties that take a sale and allocate 30% to the land, 70% to the house, whatever their allocation is in your county. And so, but what we're trying to get to, what is the correct value of the property? Isn't that what we're all here for? That's what protest is all about. What's the correct value of the property, the total value of the property? Boulder Country Club. The bane of my existence. I have a lot of favorite cases, and this is not one of them. So, In Boulder Country Club, there was a value that was changed for 99. The taxpayer protested both 99 and 2000 and dropped 2000. Once the 99 value was settled, the taxpayer filed an abatement for the 2000 value. And the court ruled, absent unusual conditions, those two values have to be the same for both years. So what I have been telling counties is that as long as there's no new construction, there's no destruction, there's no remodeling, there's no error. Because now we have Thibodeau that says you can correct a value that's not at its correct level of value. So, absent unusual conditions, those two values have to be the same, regardless of whether or not a protest was filed on that year. Sometimes, same thing happens. I had a call the other day from a county where the taxpayer filed and dropped it. And then they adjusted the other year in the cycle. And I said, I think you're stuck. I think you've got to abate it. Even though they protested. Even though 3910, 114, 1A, 1D says you can't. But under Boulder Country Club, you have to. So Huey versus Jefferson County, so this was a tax lien buyer. She found out later she bought something, open space, utility easement, swamp, whatever they buy. And they suddenly realize this is worthless. And they want an abatement. And the court says only the owner has standing to challenge that value. The tax lien holder paid at his peril and has no standing to file an abatement on a tax lien. Loprino, the postmark is the filing date. So the postmark on the envelope for the abatement is the filing date. So remember, for those of you who do abatements, you have a 2-year window. So for 2017, you have all of 18, all of 19, and the first working day in 2020 to file an abatement for 2017. So the postmark on the envelope constitutes the filing date. Woodmore Improvement District says that 2-year window holds regardless of the reason. Regardless of the reason, you have 2 years to get into the assessor's office and file that abatement, and if you don't, you lose out. The law says within 2 years. South Suburban is a case that I quote a lot. The exception to Woodmore Improvement is South Suburban, because South Suburban did not get notified of their tax bill. The assessor's office failed to change the name on the account, and so the tax bill kept going to the old owner. South Suburban, of course, was exempt, but they never got the tax bill. And they never got an NOV because the address and the owner name didn't get changed. So the court said, yes, you cannot override due process. The taxpayer didn't know about that, so he has 2 years from the date of knowledge to file that abatement. Gold and aluminum. Gold and aluminum says that 2-year time frame is that first working day in January. Because January 1, taxes are due January 1, and they have, that essentially is the due date, even though there's optional payment dates. And the court said because January 1 is a holiday, the taxpayer has until the next working day to file that abatement. This is my case. Production Geophysical was out of Denver County. It was 3 commercial businesses that were BIA assessments. BIA assessment, what's BIA? Best information available. Taxpayer didn't file. Didn't file. Finally, somebody got their attention. They said, oh my gosh, this is too high. We denied the abatements. And the court upheld us. So this is a case, I wrote the letter, had the property tax administrator sign it, testified at the BAA, went to the Court of Appeals, and I got to go watch the Supreme Court hearing. So this is probably my favorite case because it's mine. So you cannot abate a BIA assessment. Utah Motel says that any time during a year somebody has title and owns it, they are entitled to an abatement. They have standing to file an abatement if they own it for even part of the year.
Thank you for watching our presentation. We hope this format will benefit you in your work for ad valorem taxation. If you would like to provide any feedback or have any questions about the course, please contact the Colorado Division of Property Taxation.